Good afternoon, everyone. My name is Dexter Bradford, and I'm a law clerk here at Beresford Booth. And today we're going to be talking about the Homestead Exemption and what it can do to protect you. So let me go ahead and share my screen so you can see what's going on. Okay. Should be able to see the PowerPoint. All right, the Homestead Exemption. So hopefully by the end of this presentation, you'll be able to have a better understanding of what this exemption is and how it can protect you. It's pretty straightforward. Okay. Okay. So the Homestead Exemption is going to apply in situations where you have a money judgment against you. So normally a creditor can execute a judgment against the real property of a debtor. So for instance, in a situation might arise where, let's say you're involved in a lawsuit and you lose, and the other side gets a judgment against you for $500,000. Generally, you don't have $500,000 just sitting around to pay off large judgments like this. And so what the creditor can do is they can force the sale of your property to collect on their judgment. Well, in steps the Homestead Exemption, because generally most Americans, they have the majority of their assets tied up in their homes, and we obviously, don't want to get to a situation where people are forced to sell their home and their families are evicted and they're homeless. And that's just not a situation that we want to have. And so the Homestead Exemption is here to protect families and keep them in their homes, keep their homes out of the reach of their creditors. This way, individuals who face financial hardships aren't punished with homelessness. So the exemption protects debtors' residents against general creditors by exempting a specific dollar amount that creditors cannot touch. So this amount varies by state. For instance, in Kentucky, Tennessee, Virginia, those places only provide an exemption up to about $5,000. So if a creditor comes after you, you're covered there for about $5,000. It's not much. Some states offer unlimited protection, most notably like Florida, Texas, I think Iowa and Kansas as well offer unlimited protection. Your home completely covered no matter the judgment. And then notably, there's a few states like New Jersey and Pennsylvania that don't offer any protection at all. Most states will range anywhere between $25,000 to $600,000 that'll be covered. So if you're outside of Washington, obviously it's worth checking. It's a good number to know, a good number to keep in the back of your mind in case a situation like this ever arises. So we'll get to Washington's amount and how it's calculated now in a minute. It's recently changed, and that's kind of why we're talking about it. But first, we're going to talk about what counts as a homestead, because that's obviously pretty important. So a homestead, the law is designed to protect people from losing their homes. So this is not going to apply to commercial or investment properties or rental properties that you have. This, the purpose of this statute is to keep families inside their homes and prevent people from being evicted outside of their homes. And so your rental properties and your commercial properties, your investment properties really are not going to be covered. You can't hide your money in these properties and expect it to be safe. Another good thing to know about is homestead declarations. Some states require you to file a homestead declaration for the exemption to apply. Washington is not one of these states. You do not have to file anything to be entitled into this exemption. If your property falls within the definition that I just talked about, you're covered. You're going to be fine. But there is an interesting exception, something worth noting about the Washington Homestead Declaration. If you are, let's say you're living in a house right now and you're building another development property and you're planning on living there. So you're building your dream home, big old fancy house, and the house you're living in is tiny right now. And you want that big house to apply as your homestead exemption. Maybe it's worth quite a bit more than the small home that you're living in right now while that one's being developed. Then in that case, you would have to go to the state and declare that second home, that home that you're developing, as your homestead exemption. It's not going to be applied unless you do that. And once you do that, the home that you're currently living in will no longer be covered. You can't have two homes covered under the homestead exemption. So it would just be transferred over to that, that development property. All right. I think that covers homestead declarations. There are a few exceptions to the homestead exemption. So generally creditors that have a tie to the property. This is people that have mechanics liens, laborers liens, vendors liens. Those people are going to be able to get around the homestead exemption. They can force you to pay. And the reasons for this are pretty straightforward. The people that sell you your home are entitled to be paid for that home, and the people that are working on the home are entitled to be paid for, if they're building you the house. The other ones are fraud. Like, let's say if you committed fraud and that money can be traced, the fraudulent money can be traced into your home, that money's not going to be covered. That one, makes sense as well. We don't like fraudsters. And then finally, family judgments. So this doesn't apply to family disputes, divorce cases, child support, those sorts of things won't be covered under that. And so finally, here we are, Washington law. So Washington law recently just changed. The old amount was set at $125,000. And the new amount is calculated as the median home price in your county from the previous year, or $125,000, whichever is higher. So the reason that this was changed was, if you've lived in Washington, over the past decade or so, home prices have increased significantly. They've gone way up. And so $125,000 is no longer enough to ward off creditors. Your home's probably worth a lot more than that. If you get a big judgment, they're likely to still force the sale on your home anyway. You're only covered up to $125,000. It's probably not enough money for you to turn around and buy another house. It just leaves people homeless, with a little bit of money. And so the change was made to the median home price, not a fixed amount. So that way lawmakers don't have to continually go back and keep adjusting this law, because that way it's just going to be continually changing with the market. So let's look at like a real life example of how this might play out. So let's say if you have a home that's worth $730,000, let's say you get a judgment against you, get in trouble, someone gets a judgment against you for $1 million, and now they want to collect. And you don't have $1 million in cash sitting around, and your antique car collection is gone, so you don't have any money to pay this off. Now, let's say you have a home that's worth $730,000. The median home price in your county last year was $725,000. So in this case, you're in great shape. The remaining equity in your home is $5,000. The creditor is not going to force the sale, excuse me, for $5,000. It's just not worth it. They might force the sale of your home if it's worth $825,000, because they stand to collect $100,000 there. But again, if you're under that median amount, let's say the median amount again is $725,000 and your home's worth $700,000, you're in great shape. They can't touch any of it. You're going to be fine in your home. And if they do, like, let's say if in this situation they do force the sale of your home just to collect on $5,000, which is highly unlikely, I mean, you can use the credit to repurchase your home, and you're only in debt $5,000 for the value of your house there, since you're going to be credited that much anyway once they sell the property. So homestead exemption is a great thing to know about if you're in trouble with a judgment creditor coming after your property. You're not going to be hopefully you're not going to be kicked out of your property and living on the streets. There are a few Washington cases that are noteworthy here, just to keep in the back of your mind. Wilson v. Rigby. This was a bankruptcy case in the Ninth Circuit Court of Appeals that held that the exemption amount is fixed at the date of filing the petition, and it cannot be amended for a greater exemption amount due to post-filing appreciation. So what that means is basically, like in that case, litigation had dragged on, and the person wanted to go back and say, no, well, my home has increased 10-20% value, and I want that covered now. And that wasn't covered when I originally filed. You can't do that. You're going to be stuck at the time you file. That's what your home value is worth. And then next up was In Re Good. In this case, this was a bankruptcy case that the court held while the Washington law on homestead doesn't define a forced sale. Bankruptcy sales are forced sales, pretty straightforward. And then finally, the In re Weaver. This was a good case to know as well. And in this bankruptcy case, Washington State Supreme Court held that Washington residents may not claim a homestead exemption for property in other states. So if you're a Washington resident, you can't buy a big old home in Nevada or Texas or Florida and claim that you have a homestead exemption in one of those states, which is too bad because a couple of those states have unlimited homestead exemption value. You'll be stuck with the whatever the cap is in your county, and again, that's calculated by the median home price of the value of the home in your county last year. All right, I think that pretty much covers everything on the homestead exemption. If you have any questions, we have plenty of wonderful attorneys in the office that would be happy to answer those for you. And I believe that is it.